So we're going to today, and this is something I've been doing for many years at the hospital, talking to senior residents and fellows who are in the process of looking at possible employment opportunities and contracts to try to provide for you sort of a basic understanding of the issues that you need to look at when you are considering a contract for employment. So hopefully today we will familiarize you with those issues. This is an open type of lecture, so I'm happy to field questions at any time if there are issues that you want to address further. You don't have to wait till the end. I'm happy to take them as we go. So general concepts. These are sort of basics before you even start to look at the issues that pertain to a specific contract. And they may seem almost like common sense perspectives, and they are, but frankly, it's been my experience that these basic principles of common sense are not followed, sometimes by young physicians. One of the great myths is that all employment contracts are the same, so it doesn't really matter. That's simply a myth. You need to know what you're signing. There can be, indeed, major differences in employment contracts. Don't sign something you haven't read or understood. Yes, people do that, and they oftentimes regret it. If you need help, you should hire a lawyer. This is a very important document for you, and you should not be penny wise and pound foolish. Do not rely on assurances that are being given to you by a prospective employer that are then followed by a written contract. Typically, the contract will say that whatever in this contract is all there is. So any verbal assurances that you receive before from that prospective employer that have not found their way into the contract are not binding on the employer. And the final point, unless you're going into an underserved area where your services are desperately needed by the employer, the truth is you're coming out of a residency or fellowship training program. You're probably not going to have a lot of contract leverage. You're not bringing a practice with you. So your expectations should be realistic. You may be able to get some changes to the contract, but maybe not a lot. So there are some general types of employment scenarios. I've got three here that I think cover the waterfront for the most part. One, of course, is direct employment by health system. In this health system, we have employed faculty. This is very common in a lot of your large academic medical centers, and increasingly common even in some what we would designate as community hospitals. There's been a major sort of second wind on hospital systems trying to acquire physicians from an employment perspective. And you may find that even a traditional community hospital system will now have its own group to attempt to capture patient base. When you're employed by a health system, the truth of the matter is that they draw contracts that are meant to apply across the board to potentially hundreds of physicians. So your efforts and ability to individually negotiate provisions are limited. Employment by a health system, of course, you're trading the possibility of an equity ownership interest for possibly less economic risk and less administrative responsibility. If you're employed by a private group, you probably are going to that group because you have a desire at some point to become an owner of that practice. Unlike a health system agreement, what we find here is that these employment arrangements are typically much more business-oriented. Compensation may have less of a guaranteed salary component and more of a productivity outcome, although, as we'll discuss later, that's definitely changing, even in the health system world. And you may have a little bit more room for individual negotiation. This is something that's a hybrid. Under federal fraud and abuse laws, it is possible for health systems to fund private groups' recruitment of residents or fellows out of programs. And what typically happens is the health system will make what is essentially a loan to the private group, and to the new physician, where they will subsidize the group's compensation of the new physician for a period of time, usually up to 3 years. So that subsidy is a loan. And that loan is a binding obligation on not just the employing group, but the physician who's being employed. And that loan would be like any other loan, subject to repayment, but for the fact that typically the loan has a forgiveness component to it. And that forgiveness component allows you to basically work that loan off by remaining in the area for a certain period of time. So this is a complicated arrangement with a lot of paper. I would very much recommend to you that you do not consider one of these arrangements without legal assistance. They're very complicated deals, but they are out there, and you may well be recruited for one of these. So, this is a very important point. In some private contracting arrangements, I have seen groups take the position with a young physician that we really want to bring you on as an independent contractor. Why? Because then they don't have to provide benefits, they don't have to withhold taxes. And the truth of the matter is, I've never seen a legitimate independent contract arrangement in that setting, because under virtually all laws, you can't be an independent contractor when you're working full-time for a single employer that controls your employment. It's just not an independent contract relationship. This should raise a major red flag with you if someone wants to bring you on as a full-time person working solely for that group on an independent contract basis. That is typically not an appropriate arrangement. So you should call that into question if that should happen. So typically when you're involved in a prospective employment, you have to make sure you get off to the right start. And this is really not so much a matter of what the contract says, but again, a matter of common sense. That group wants you to be able to start and be in a position to bill for patients as soon as possible. That means you'll probably be signing your contract some months in advance of your start date. And when you do that, there are going to be prerequisites, particularly if you're going to a state where you're not yet licensed. You have licensure, you have hospital medical staff credentialing. You may have to be credentialed for that prospective employer's managed care contracts. So you have forms that are going to be filled out, information that you're going to have to provide. You can't ignore that, right? That's important that all get done. If you show up and you're not ready to go, you've already put yourself behind the 8 ball with that employer. So I caution you that if there's things you need to do to be ready to start on the day in question, do not let this thing sit on the bottom of a pile like perhaps I've seen in the past where people's insurance policies lapse, their driver's licenses don't get renewed, their vehicle registrations don't get renewed. You can't allow that to happen in this type of setting. So there are many, many contract issues, and we're going to take them not necessarily in order of importance, but all of these issues I think are going to be things that your knowledge of them will help you enter into a better agreement. So contract term is important. How long is the contract? And how definite is the term? If a contract employs you and there's not a definite start date and a definite end date, that contract basically treats you as an employee at will, which means that that employer could terminate you at any time with or without notice, and you can leave at any time with or without notice. But there's no job security with a contract that does not have a definite term. But almost always now, in today's era, even if the contract does have a definite term, starts for, let's say, July 1, ends on June 30, quite frequently, these contracts will have provisions in there that allows either side to terminate that contract in a much shorter time frame. So there may be a provision there that says that your employer and you, or maybe just your employer, can terminate the agreement on 60 days or 90 days notice, even without any reason. Well, what does that mean? That means that that year contract is really in effect a 90-day contract. So if you really want job security in the term of an agreement, you need to have a definite term And you need to have a situation where it cannot be terminated by either party during that term on a short notice type of provision. You're going to find it very difficult to find a contract like that out there today. It's almost always the case that we're finding these arrangements where there are termination without cause notice clauses. And if you can avoid that in your first year so that you can have a nice settled contract term, that would be great. But you need to pay attention to that. Because calling the contract a year contract with a provision that allows for termination in a short period of time basically negates the time frame. There's also, on the other end, sometimes you'll find in these contracts where a contract may have a year provision and then it may automatically turn over for another year unless either party gives notice that they don't want to continue the relationship. And that notice sometimes has to be given within 90 or 120 days of the end of the contract term. Pay attention to that because you may not want to stay there for another year. If you don't give appropriate notice, you've bound yourself for another term. So if there is a provision for non-renewal and a notice that's required, you need to be cognizant of that and aware before you sign the contract. Almost always physicians say to me, well, if I have a year contract and I'm terminated early, do I get severance? The answer is no, unless the contract says so. And virtually none do. Job duties can be an issue. Obviously, your employer is going to have very broad discretion in assignment of work, and typically the contracts will have very broad language asserting the employer's right to assign work to you. But sometimes in those recruitment meetings, you will ask questions because you have concerns about, for example, how much call or weekend coverage will you have? What kind of non-clinical activities are expected? Will you have to go to multiple clinical sites? If you're made certain assurances in that regard, and they don't appear in a contract, you need to have an addendum that confirms those assurances. Because otherwise, without that, you could be subject to whatever duties and schedules the employer could request of you. So you could be in a very unpleasant situation, albeit for whatever the term of the contract, but nonetheless, this is a situation which if this is important to you, if it's important to you, you need to make sure that it's handled in the agreement. Same thing with exclusivity. Typically, that employment agreement will say that you're working for me, that's it. You can't moonlight, you can't do things outside. If you want to engage in other outside activities, serving as experts, moonlighting, you have to be sure that that's allowed under the contract. And then sometimes, even if it's allowed, who keeps the money? If you want to be able to engage in services outside the scope of the contract and retain the remuneration for that, you have to make sure that those issues are dealt with up front. Most health system contracts, for sure, will require you to disclose any type of outside activities that might impact upon your duty of loyalty to your employer. One final point. Even though it's not typical for a resident or a fellow to have invented some process or have been involved in some research with intellectual property rights, it isn't impossible. If you have an interest in intellectual property, you have to be sure that that's accepted from the contract you're entering into with your employer, because typically in a large health system, they will take the position that they own all intellectual property pertaining to you. So if you have things that you've been working on before you went to the system, you should make that an exception to the contract to protect your interest in that intellectual property. Compensation. This is a wildly changed area that's going to only get more complicated as we go on. So let's talk about this. Most fellows and residents, if you're going to work in a health system, and even in a lot of private employments, in that first year you may well and more likely than not will receive probably a stated salary or compensation. But that may only exist for a short period of time because most health systems and your larger private employers are basing compensation on a complex of factors now. Most commonly on productivity, the relative value units that you accumulate in the performance of your clinical services. But also, we're finding that there may be compensation triggers that you must meet to receive your full compensation by meeting certain patient satisfaction or quality issues. Why? Because oftentimes, at least in the case of the health system, under certain payer arrangements, particularly Medicare, achievement of certain quality or patient satisfaction standards are required or the hospital gets penalized in its compensation. So there's a flow through. We're seeing more and more into the physician compensation plans where it's based not just on a stated salary, but based on productivity, quality, patient satisfaction. And that may impact both base compensation, or it may be targets that would allow you to achieve some sort of positive incentive compensation on top of it. So you may find these compensation structures to be a little bit more complicated than what traditionally used to be just basically a straight salary type of arrangement. As far as bonuses go, there's no legal obligation for an employer to pay a bonus, even if you achieve standards of performance that you think are well above and beyond what should have been expected of you. If it's not in the contract, you're not entitled to a bonus. And even if it's in the contract, if the language is written in an ambiguous fashion and all discretion rests with the employer, that's not really bonus language that entitles you to anything either. If bonus is important, you need to have specific language that tells you what do you need to do, hopefully objective criteria to achieve a bonus, and that if you achieve that criteria, it will be paid. If it's not written in that fashion, it could well be simply an amorphous promise that you will have a hard time actually enforcing. Benefits. This is where I said at the beginning that it's important for you to really read contracts because there can be a big difference in contracts based upon benefits. Benefits can be worth a fairly significant percentage, 28, 32% of your base compensation. Think about the cost of various insurances today. Maybe some of you are currently paying out of pocket for some of these insurances. So it's very important to try to compare apples to apples when you're looking at these contracts, particularly with insurances. You know, what type of health or coverage are you receiving? How much of an individual contribution must you make? Is there life or disability insurance being provided? What type of pension plan does the employer offer? Those are all issues that have dollar value attached to them and can be the difference between one contract to the next as to which one is more lucrative. Similarly, what type of PTO allotment are you getting? Is PTO applied to everything, or is there specific vacation carve-outs, or is it applied to any time off for any purpose? Does it carry over? Is it use it or lose it? All of these issues can vary from contract to contract. So if you don't pay attention, you may not be comparing apples to apples. It's also the case that most contracts will afford some level of reimbursement for CME attendance at seminars or conferences, subscriptions, memberships. But again, I've seen very wide variations in the amount that's allowable. Again, pay attention. When you're comparing contract offers, that could be a material difference. I've seen recently a provision that sort of disturbs me, which is a provision for a clawback of reimbursement. So you get an expense reimbursement for being on a conference, and for some reason or another, your employer can't take a deduction for that on its tax return. I've seen provisions in contracts where they say, well, if that's the case, we can claw that money back from you because we couldn't get a deduction for it. I would strenuously object to that provision. Malpractice. Obviously, quite important. But all insurances are not the same. Obviously, limits of coverage is important. The more coverage you have, the more protection you have. When you work for a big health system, you probably have a basic level of insurance, but you'll have many layers of excess insurance over that. Not so much in a private employment setting. Typically, in many states, there's a sort of a minimum required amount of insurance that you have to carry to be licensed. So typically, the employer's contract will at least provide that level of coverage. But depending on your specialty, depending upon what you think is the market for that coverage, you may find that you don't have adequate limits. You have to look at the structure of that program. Now, a lot of health systems, there's a certain level of insurance provided which is self-funded through a trust or some other arrangement. In a big health system, that should not cause you a lot of concern. In a small group, if they have some other alternative arrangement other than commercial insurance, you really need to take a look at that. Not typical, haven't seen much of that. Typically, the smaller groups are purely commercial coverage purchased through a typically solvent carrier. There are different types of malpractice coverage, and this can become an issue later. Malpractice comes in two flavors: occurrence-based, claims-made. So, what's an occurrence policy? That policy says, during a policy period of time, if something happens, my policy will cover you for that event, no matter when the claim is made. So, if you have let's say a pediatric patient and the claim doesn't get made for 7 or 8 years later, that policy, as an occurrence policy, will cover that. That's an expensive policy for most, particularly smaller groups. The other type of insurance, which is a little cheaper, is what they call claims-made insurance. So what claims-made says is, during the period that I'm covering you, I will cover you for any claim that's made during the policy period. Except that I'm going to put a retroactive date on that, and anything that happened before then, even if the claim is made during the policy, I'm not covering that. So that could be very limited coverage. Sometimes the retroactive date is the day you start employment. So it can be pretty limited coverage, frankly. So when you have a claims-made policy, and you stay employed there and the policies continue to flip over, and that retroactive date still stays with your original employment, no problem. But what happens when you leave employment and you go somewhere else to work? What happens to that claims-made covered policy? Because now, if a claim is made while you were in a new job setting from something that happened while you were in the prior employment, that policy doesn't cover that. You need to have what's known as a tail to that coverage, which effectively converts that policy into more or less an occurrence policy. That tail can be very expensive. That tail can be as much as a year's premium or even sometimes a year and a half's worth of premium. Who's going to be responsible for paying for that? Because you can't leave yourself exposed or uncovered. Your new employer may or may not be willing to pick up the cost of your tail. So obviously, what you'd like to have is a situation in your contract where your current employer will pick up the cost of the tail. That's an important provision to have in a contract, or at least to know what the limits of that ability to provide tail coverage would be. Sometimes, for example, the employer may choose to provide tail coverage if you leave because the employer has asked you to go without cause, but won't provide that coverage if you were terminated for cause or if you resigned of your own free will. That's the type of things you need to look at. Under many state laws, there may be an opportunity for indemnification against your employer that in cases where the insurance coverage is inadequate. Because you're a servant, you're acting on behalf of the employer. That's kind of an amorphous problem, which may vary from state to state. That's why what you really need to focus on is how much insurance you have. Okay? And please pay attention to the distinction that we just addressed between occurrence or claims made coverage. So, almost every contract obviously is going to have a provision for termination for a cause. The question is, what is cause? Is cause something that you can objectively evaluate, or is cause something subjective in the mind or eye of the employer? From your perspective, the more objective the criteria, the easier it is for you to be able to understand what is within appropriate conduct and what is not within appropriate conduct. Also, cause can be structured in a way where your question will be, can I be terminated for some minor infraction that's not really material? So you would want a contract to lay out reasons for termination that are material in nature and not simply potential ways for the employer to unfairly terminate your employment. Most employment contracts will have very general provisions that say that you can be terminated for cause if you don't follow appropriate policies or procedures of the employer. I understand that, but you may want to have provision built in there that if there is some type of catch-all breach language, that you are going to get some type of notice, that you are in violation of some policy or procedure, and an opportunity to fix that problem before you can be terminated. So that opportunity to cure is something that when I was in private practice, I typically tried to make sure that my physician clients had that type of language in their employment contract. If you're working for a major health system, you're probably going to find that once your job ends, so will your privileges at that health system. There's typically an automatic loss of privileges provision, and there's no due process for that. So another, I think, critical issue that comes up all the time in employment contracts are your post-employment restrictions. Will you have a restrictive covenant or won't you? The chances are, unless you're in a hospital-based practice, you don't maybe not see it as frequently with some hospital-based practices like anesthesia, but generally speaking, I'm pretty sure that whatever contract you're going to be looking at is going to have a restrictive covenant. This can be particularly troublesome if you're relocating to an area where your employer may be the only hospital within 50 miles, may have essentially a monopoly of services in a particular geographic area. So it's very important to understand that restrictive covenant. How long will it be? How big an area is covered by that restrictive covenant? When will it take effect? Does it take effect if you're terminated without cause by the employer, or only if you do something wrong, or if you choose to resign? Does it prevent you from having hospital privileges within the area? Or is it more general than that and would prohibit any type of medical practice within that restricted zone? Are there pre-selected remedies? What happens if you breach that contract? Does the contract provide for specific remedies? Some of them do. Some of them may have liquidated damages that could be as much as a year's worth of your compensation or some other number. Those pre-selected remedies are very important to understand and can be pretty onerous. Generally speaking, in most states, this is not true across the board. It's true in New Jersey. It's true in many other states. A court will enforce a restrictive covenant against a physician, provided the covenant is not unreasonable in length or in geographic scope. Because an employer will say that, by employing you, We provide you with a certain level of training. We provide you with access to our policies and procedures, our strategies, and our patient base, putting you in a position to be able to unfairly compete against us if you leave. Most courts buy that and will enforce those provisions. So I've heard many young physicians say, well, I heard that these things aren't enforceable anyway, so what difference does it make? That's wrong advice. That's bad advice. These covenants are typically enforceable. And believe me, I've seen health systems in this area go after physicians who have breached those restrictive covenants. It can be a major problem. So I think you need to take that into account in assessing whether that contract, if it doesn't work out, will put you in a position where you may not be able to be gainfully employed in the area. And I've seen mileages vary. If you're working in a big city environment, half the time you may not see a covenant that's more than 5 miles. But 5 miles in a big city covers a lot of territory, right? Whereas if you're out in a rural area, it might be 25 or 30 miles. Sometimes a court will enforce a covenant at a greater level for a specialty than for a primary care practice. Sometimes a court won't enforce a covenant if they feel that you've been the victim of unfair treatment by employer. For example, they breached your contract. If you're going to leave, if you're concerned about a restrictive covenant, I would recommend that you have a lawyer look at it and advise you before you accept employment elsewhere that might be violating that covenant. Also, you'll find, and this is probably not a big issue for most of you, but you will find in contracts non-solicitation clause, which basically says that you won't try to encourage other people to leave their employment to come work with you. Again, on the employment side, on colleagues, I doubt that's going to become a big issue for you. What's more important and a bigger problem are non-solicitation clauses that deal with patient contact. Typically, a patient certainly has the right to see and continue to be seen by whatever physician they want. The question is, how do you make contact with that patient to let them know that you're leaving? Many employment contracts say that you won't make that contact. While you're getting a paycheck from me, you won't be telling the employers you're leaving. You mean the patients that you're leaving. You won't be giving them your contact information. We'll provide that information after you're gone. And I've seen physicians attempt to take information off the computer to be able to basically sidestep those restrictions. Not a smart idea. That can get you in trouble under both state and federal computer piracy laws. So once again, these provisions have some meat attached to them and may make it difficult for you to contact that patient base. What you can't be prevented from doing is going to work and putting an ad in the newspaper saying, Dr. So-and-so has relocated his or her practice to X. It typically cannot prevent that. What can be prevented are individualized patient contacts. Seeing that patient in the office and saying, I'm leaving, so I would suggest you not make another appointment here because I'm going to be working somewhere else 2 months from now. Why don't you call that group and make the appointment? That would be a violation, clearly. And if found out, you could be sued for damages or an injunction to prevent you from continuing to do so. So again, probably going to see it in most contracts. It's not a throwaway provision. Dispute resolution. I've seen a number of contracts, probably more and more, that provide that if you have a dispute with your employer, you have to resolve it through arbitration as opposed to going to court. Arbitration is often held out as a remedy that is less expensive, more quickly resolved, less formal, and therefore, in the eyes of some, a better way to resolve disputes. I'm not so sure of that. I wouldn't walk away from a great contract because you have an arbitration clause, but I prefer that they not be in there. Whenever I could, I tried to negotiate those out. Also, you'll find forum selection. Don't be surprised that even if you have a right to sue your employer and you work in California and come back to New Jersey, that if you want to get into a lawsuit with your employer, then you're going to be doing it in California, probably under California law, enforceable, typically. So, as we talked about at the beginning of the program, one of the lures of going into a private group, obviously, is the hope that you will someday have the opportunity to become an owner of that practice. Once again, those assurances are meaningless unless committed to writing, right? So what type of arrangements might they be? So many states will advise as to what type of form a physician group can practice in. Normally, it can be a professional corporation, a limited liability corporation, a partnership, a limited liability partnership. There are a number of different vehicles, corporate vehicles, through which a physician group may practice. And all of those would have equity potential in one or more different formats. So the question going to arise as to, what are the criteria under which you could have equity participation in the group? How long do you need to work there? Are there objective criteria for that? Or is it a matter of you being told after working there 2 or 3 years, you're just not a good fit? The more objective the criteria, the more you know what you need to do in order to achieve equity status, the more definite the promise, the more appropriate and viable is that offer of equity participation. But it may not be for free, obviously. You may have to buy into that practice. You may not just get a piece of the action, if you will, based on sweat equity. You may have to actually pay for the value of that percentage ownership based upon an accountant's financial analysis of the worth of the organization. And that may take into account all assets, including accounts receivable, and you basically would pay for that a share value based upon the current financials analysis of that particular corporation. And you might have to do that. There are different ways that groups do this. They allow you sometimes to buy in over time by taking an adjustment to your salary, which is probably the least painful way about it. Others, you may have to go out and get a loan and pay this off. So again, equity participation, if that's an important element of you saying yes to this group and no to that group, you need to be sure that there is adequate meat on the bones there, that those assurances are somehow in writing. Otherwise, you have really nothing but trust, really, to base that decision on. So that's basically a whirlwind tour of the issues. Well, good luck to you. I hope that you have a successful hiring season and that you enter into a good contract. Thanks.